The defendant is on trial not for being a police officer. It's not the state versus the police. He's not on trial for who he was. He's on trial for what he did. That is what he did. That is what he did on that day. 9 minutes and 29 seconds. That is what he did.
That part of the closing arguments from the prosecution in the Derek Chauvin trial. At the top of the program, we showed you other powerful moments from both sides today. Now I'm going to bring in someone with the perfect resume to analyze what we've both seen and heard. Dan Herbert, former Chicago police officer, one-time Cook County prosecutor, now criminal defense attorney who has represented hundreds of police officers over the years, and he's joined us before over the course of this trial. He's kind enough to give us a few minutes tonight. Daniel, again, from the layperson here in the closing arguments, not shocking, the arguments or that were restated or repositioned to the jury, but there seemed to be some Hail Marys thrown in from the defense counsel, including things I'd never heard brought up at trial at all, where he said it basically was the EMT's fault, possibly because they didn't administer Narcan or some of these things that I didn't hear come up. Is that a little dangerous when you're laying out to a jury something you never argued of your presentation? All of a sudden now you're bringing it up in closing?
It really is. The defense counsel, you want to maintain that level of credibility with the jurors. And what the jurors are going to do is they're going to look back to what you promised them at the beginning of the trial. And if you're bringing up things that you never mentioned at the beginning of the trial and they weren't referenced during the trial, I think that has a potential to at least cause some dissatisfaction with the jurors. But at the end of the day, the defense case is much more of a Hail Mary than the state's case. So that's probably why they're going that route.
There was also, and again, maybe I'm going to the literal language, but the argument that the defense counsel was laying out was that to find his client guilty, Officer Chauvin, he stated his actions were the only cause of Floyd's death. If you don't find that to be the case, then you got to let my client walk. When in fact, as I understand Minnesota law, Daniel, it's that if his use of force, Chauvin's, was a substantial causal factor, that's enough of a standard. That's an important distinction with a difference, isn't it?
It really is. And, I was listening to the arguments. I'm, of course, trying to do some work myself. But it's normal for both sides to show the jurors, here's the jury instructions that have already been read to you, and this is what you're going to get when you go back to start your deliberations. And I did not see him reference that jury instruction, which there clearly is one. And like you said, Richard, it spells out that it may not be the only cause, but it has to be a substantial factor towards the death. So it's really important that the attorneys hit on those key element points. And I'm hoping he had done it at some other point during his closing, but I didn't hear it.
And obviously, it's going to be important when the judge charges the jury and the instructions as to that. But as I mentioned in the intro, Daniel, you've been on both sides of this. Help me out strategically when you've got multiple charges facing either someone you're prosecuting or more recent years defending. Are you picking the one that you're most worried about and making that the focus of the close and maybe reading the room here and saying, listen, I'm going to have a hard time getting Chauvin off of manslaughter here, but maybe best case scenario, he's not convicted of murder 2 and 3. And from the prosecution side, you say, listen, this case went so well. I never thought I was going to get murder 2, but might as well give it a shot now and really close hard on that. Give me the strategy involved on both the prosecution and the defense when you got 3 charges, what you're trying to convince the jury of.
Yeah, it's a really good question. And from the prosecutor's perspective, clearly they recognize that there couldn't be what we call splitting the baby here. The jurors might not all agree on second degree, but they can reasonably agree on a third degree or even perhaps a manslaughter. So the prosecutor's goal is they want to argue that second degree as strenuously as possible, show how all the elements meet that second degree, and then touch on third degree and manslaughter, but focus on those, let them know that they proved their case with the highest charge. And if they want to kind of bargain it down in the juror room, then I assure you the prosecutors would still probably be satisfied with the third degree here. With the defense, they definitely want to hammer the points that the state failed to prove the elements of the case. That's their biggest bargaining point here, is the burden of proof. So they want to show that the state didn't prove the elements of these cases or of these charges, and then they certainly want to focus on some specific charges. Not only can it not be second degree, but that's preposterous. But even the third degree, even the manslaughter, that's preposterous because of these points. The defense has to focus on it in kind of the reverse order than the prosecutors do.
And then we just deal with reality in that these jurors have not been sequestered. They don't live in a hermetically sealed bubble. They're seeing, whether they're supposed to or not, they know about boarded up shops. They know about what happened 10 miles outside of Minneapolis with the Daunte Wright shooting. How much of that has to be a concern if you're the defense right now to say, if my client walks, the jury's got to have on their minds that there's going to be riots, or my God, this is not a one-off. There's a climate that's going on right now, and people are going to be looking at this case as basically a litmus test as to where we are with policing in America. How much of that has to be part of the equation, especially if you might go to the prosecution and say, okay, what kind of deal can my client get?
Yeah, I doubt that there is any plea bargain discussions at this point. These are types of cases that there generally are not plea discussions because the state's offer would be essentially, take a plea on second-degree murder, and we'll give you, half of what the maximum is. So generally, these cases, there is no fruitful plea bargaining discussions. But Richard, I agree with you, and some people might call us cynical, but I believe that the jurors do know what is happening. Perhaps not in as much detail that you or I may, but they certainly know what's going on. And as far as the impact that it has, it is huge, the impact that it has on essentially the defense in this case. It is very, very powerful, persuasive, and overwhelming for a juror to come back and make that tough decision here. And let's be honest, the easy decision here is guilty. The tough decision here is not guilty for a number of reasons. But knowing that the city is going to go up, knowing that they have to go back to their city at some point, and knowing that their identity is going to be revealed, it's simply just too much pressure and a burden to be placed on a juror, in my opinion, to render a fair verdict.
Finally, as I mentioned before, you wore a uniform, and you've known every side of the law here. To that end, we're both maybe we call us realists or cynics, whatever they want, but does this have a chance? Because I've been struck by how many, former police chiefs that I've had on the show, whatever, not one of them sticking up for Chauvin. Does this have a chance to have some tangible, overdue conversations about reform, or is this just going to have a chilling impact on law enforcement, that this might go the other way, where all of a sudden people aren't going to respond to calls in certain places because they don't need it in their lives? What are the stakes here in terms of policing?
Yeah, this case, I've always considered this case a bit of an aberration out of a lot of the use of force cases, because there usually were pretty good arguments on both sides as to why the force was appropriate, why it wasn't. As you mentioned, in this case, it was almost universal that the force here was not appropriate. And, and that's why they certainly focused on that causation issue in this case. In a lot of ways, this case really was a setback to law enforcement and proponents of law enforcement. So I think that this case may not have the chilling effect on police officers that other cases do. And if I can just give you a very recent example, the city of Chicago, we had that tragic situation where the young boy was shot by a police officer. That's a situation, if this officer were to be charged, that would be a case where the chilling effect it would have on police officers would be felt nationwide. And that would really be impactful, I think.
And I agree with you. And we're talking about the Toledo case. Dan Herbert, I appreciate the time as always, and I'm sure we're going to talk again when we get a verdict out of this. But till then, be well.
Okay, you as well. Thank you.
We come back, everyone. The subject of violence, specifically gun violence in America, has reached epidemic proportions. Frankly, we've been there for a while. It's taking on a huge toll on our children, even when they survive a shooting. After the break, the author of a fascinating new book that gets into just how devastating it is for kids after they witness gun violence with their own two eyes.